Hey, good morning, everyone. Welcome to Senate Judiciary. Good to be back. We've got three bills for our consideration in committee. They'll be familiar, of course, depending on what the other side did to them. But we have three committee bills this morning. The first one for our consideration is House Bill 31, Peace Officers, Records and Reporting. Representative, it's good to have you here. Would you be willing to walk us into House Bill 31 and tell us how it went on the other side and remind us of the work we did during the interim?
Sure thing.
Thanks for being here. Appreciate
you.
it.
Thank you, Mr. Chairman. I'm happy to walk you through this bill. House side didn't make too many changes. Well, I'll get to those when we get there, but I just want to remind Eddie why we're here. This bill is a result of an Albany County case this past summer where the Peace Officer Standards and Training Commission ultimately had to sue the Albany County Sheriff for records for a investigation that they were conducting on a sheriff's corporal in Albany County. That investigation started in January of 2020, and I believe it was maybe the fifth attempt to get personnel records. What the district court judge ruled was that our state statutes are ambiguous. They're not clear enough, particularly in the public records law that say you can't hand over personnel files to anybody that's not the direct supervisor of law enforcement. Post has had issues with this in other cases. But the dire thing that has happened because of that Albany County ruling is now agencies it has a chilling effect on agencies. Why would you hand over records if now the courts have said it's illegal to do so? So they risk potential litigation. And I know that was the concern of the sheriff in Albany County. So what this bill does is it closes that. It allows for Post, who is the certifying body of law enforcement, to be able to be able to get access to those records if they are in fact doing an investigation into someone's certification. You'll likely hear from law enforcement today, something that we heard on the other side is that this bill is taking us down a dangerous path of allowing access to records. We did make some changes on the other side specifically to that. So what you'll see is, and I'm looking at the original bill, but I think the language will basically meet up on page 2, line 5, and what we have is a portion of a personnel file relevant to any of the qualifications specified in subsection B. So it relates to other statute. But this is saying what our amendment does is it puts in after file, it says that is specifically related to a complaint. So some of the concerns that we heard in committee was this idea that maybe Post will go rogue and start a witch hunt and try to get officers in trouble. I disagree with that concern, in part because Post is a body of the Attorney General. They have to answer to the Attorney General. The other issue when you try to decertify an officer is that you're looking at the Office of Administrative Hearings. So it's a checks and balance issue. This is the only way the government is able to have accountability in cases where maybe a local sheriff is not. And in the case of Albany County, that is exactly what happened. So this is just to ensure that government runs the way it's supposed to. You'll also see those amendments in the other sections of the bill that relate. It's exactly the same, related to a specific complaint. That's on page 3, line 9, after file. And then we have it on page 4, line 11, portion of a personnel file related to a specific complaint. And then on page 5, lines 22, related to a specific complaint. So that's the summary I'll give you now. If you have any questions, I'm happy to answer them. Thank you, Mr. Chairman.
Appreciate you being here, Representative. Thank you. Committee questions of the good representative, Senator Schuler.
Thank you, Mr. Chairman. So I guess I have a question on on page 3, where the portion of the file that specifically relates to the complaint it has to be relevant to the qualifications. For some reason, when we were working the bill in the interim, I was thinking that they could use post also to look back and see if there were any complaints in the past from other states or other areas to kind of decide whether or not they would be a good fit for their area. So does this take that away?
Representative?
Thank you. We have the director online. I think the answer to that is no. Again, I think in other states, they're going to have different statutes that they have to fall under. I know in the specific case in Albany County, there's been struggles to get records from Nevada, Las Vegas. The officer involved in this case, his behavior in Las Vegas resulted in a $100,000 lawsuit. And I think Post has tried to talk with that Post Commission, but because of their state statutes was unable to get it.
Other questions of the representative? Representative Provenza, thank you. That's very helpful to catch us back up on where we left off during the interim. Let's stay as long as you can, or feel like but we're good if you have to get back across the hall. It's very frustrating, by the way, for those of you joining us this morning, that our Judiciary committees meet at the same time. And hopefully in future years, we can get that part corrected, because there's a lot of cross-informational opportunity that we lose. But thank you, Representative, for being here. I want to go to the Post Director next, and I understand he is online. Thank you, Pierre. If you could let Mr. Walsh in this morning. Okay. Director, thank you
Good
for
morning, Mr. Chairman, members of the committee.
being with us. We appreciate it. Talk to us about House Bill 31, Director, if you would, and welcome. It's good to see you again.
It's good to see you too as well, Mr. Chairman. And I can address one of the questions from Senator Schuler, I'm sorry, about looking for prior complaints and backgrounds. That is typically done. Statute lines out broad standards for all agencies in their hiring and their background checks, and that is typically done at the very beginning. Now, if a person had been decertified in another state, we also follow up with the next level of review through the National Decertification Index. And if we find a person that's been decertified in another state, then I won't issue a certification in this state until the home state issue has been resolved. And in general, I believe Representative Provenza covered it well. Just to give you some data on decertifications or in complaint investigations, they're not always the same thing. Over the last 4 years, of about 133 investigations, 62 of those complaints came from the parent agency. 6 of those 6%, I'm sorry, were brought to me by other law enforcement agencies in the state. 13% of those complaints were initiated by myself, and 19% of complaints that have come in were brought to me by citizens. And of the 13% that were initiated by me, almost exclusively that was information provided to me by the parent agency on an arrest or a similar situation, and then left at my discretion whether I opened a case or not.
So, Director, thank you. Committee questions for the Post Director this morning? I guess I've got a couple, Mr. Walsh. What prompts? Can you just cover what prompts an investigation? You kind of touched on it there, but I'm just trying to make sure I've got a handle on is it when you hear of an officer involved shooting, for example, or is there some automatics in there where you automatically look into certain situations that might occur?
Well, thank you, Mr. Chairman. The automatics would be if I started, where I read a headline or, somebody drops me a tip that says this officer was just arrested for, say, domestic violence, a felony level call, then I'll look into that, of course. Typically, a complaint comes in from the parent agency with a background packet of their internal investigation, and submitted to me with a request for decertification. That's the standard method. Other methods would be a citizen calls up and makes a complaint. Now, oftentimes a citizen complaint is very similar to what a department would get. They just come to my level, but it can be everything from I'm being targeted because I've got an out-of-state plate and I got a speeding ticket to I believe my civil rights have been violated. I'd like you to look into this. Or another agency will report similar information. As far as officer-involved shootings, that's not an automatic trigger for me to investigate. However, some officer-involved shootings are presented to me for review and investigation. So, in general, I'll accept a complaint from anyone. I don't discourage people from voicing their concerns. If it's more appropriately handled at a department level because it's a low-level complaint, I'll return that to department. If it appears after a cursory investigation that it's a violation of post rules, then I'll investigate it. I will then submit my investigation to the person who acts as a prosecutor for me in the Attorney General's office. They'll review it. If they concur that we need to move forward, we'll request a hearing through the Office of Administrative Hearings, where it'll be heard before an administrative judge in Wyoming.
So, Director, I think we understand, what prompted a look at this particular statute, and not to put you, you're a part of the Attorney General's office, and so I don't mean to put you in a political spot, but are you concerned in any way with anything in the bill? I mean, talk to us about the bill itself. Any concerns?
Mr. Chairman, I don't have any concerns with the bill. I think it addresses an area that was just maybe not considered when the law was initially written in 1973. As far as access to the bill is only allowing access to the areas that Post is supposed to verify anyway. So it just grants actual access to the records.
Okay, thank you very much. Anything else, committee? Director, thanks for being online with us this morning. Appreciate if you can hang tough. We may have a question later. Appreciate that. I want to go to any other agency folks. Please come forward. We've got some of our good troopers here with us this morning. Appreciate that. You've got them right where you need them now, Representative. There you go. Good morning, gentlemen. Yeah.
Senators. I'll be brief. We support good policing, accountability in our police officers. We commend the work done of Director Walsh and the Post Commission. I just have a couple concerns about the bill. Anything that's titled personnel records, obviously. I think as the bill's explained, or as I understand it, it's designed to support the request by Post for specific records that would corroborate decertification or the ability to look into a peace officer certification. I think there's some wording in the bill that is concerning to me, and that would start on line 14. In fact, one of my recommendations would be to strike investigating on line 14, and then on line 17, suspension, revocation, or termination.
Sir, line 14, what page?
I'm sorry, sir, on page 2.
Okay, page 2.
Yes.
We need, the other thing is, we are operating off of what they call an engrossed bill because it now includes, officer, it includes the House amendments that were brought in, so,
Mr. Chairman,
yeah, I think, go ahead, Senator Case.
well, forgive me, but I did not catch the gentleman's name. I'm not sure you provided it. Maybe you
I'm
did.
sorry, yes,
Thank
yeah.
you. Yeah.
My desire to be brief.
That's on me. Thank you, gentlemen. If you would introduce yourself.
Yes, sir.
Appreciate
Chairman,
that.
Senators, Colonel Tim Cameron, I'm the Administrator of the Wyoming Highway Patrol. And with me is Lieutenant Colonel Josh Walther from Highway Patrol. Thank you.
Thank you for that. And please continue, Colonel. So I think that probably in the green version of the bill takes us to about line 15. The Vice Chairman pointed that out to me. Can you take a look and see if that amendment helped in any way, or talk to us about that?
So I appreciate the amendment, which I think inserts the worded, including the necessity that is specifically related to a complaint end. So I appreciate that complaint, and I think it gives it more specificity. But one of the things it does, probably unintentionally, is open the door to the questions of what kind of complaint. It wouldn't be germane for a criminal complaint. That would be investigated by potentially another agency. What's the time frame? Is there a requirement on the time frame of the complaint? And also, how is the complaint made? Is it required to be a written complaint, a verbal complaint? Can a third-party complaint be made? Again, that's the kind of things that the amendment, in my mind, opens the door. Again, and I have a copy there. I've made some notations on recommendations for an amendment. Would that be easier just to provide that to you?
Absolutely. No, that would be great, Colonel. When we get done visiting, you could sure, if you need it for notes.
No, sir.
Otherwise, go ahead.
I'm
All
good.
righty.
And again, my recommendation, to stay specific to how I understand the bill, and I don't think it changes the intent at all, would be on line 15, and I'm working off the green copy now, striking investigating or, which is at the end of the line. And it would stay initial certification or continuing certification, and then strike suspension, revocation, or termination. So by leaving in initial certification or continuing recertification, I think it satisfies the stated objective of this entire statute, which I would point out, and this is repeated in each section of the red addition to the bill of the same language, suspension, termination, revocation. But in the current statute, Section J speaks to the case of a termination of a peace officer and how the commission goes about that. And I think, again, as I've understood the testimony both last session and this session, to be specific to some agencies feeling uncomfortable about providing certain corroborating records, which I agree. I agree 100% that we should be able to supply those records specific to post-examination or review of certification or recertification.
Colonel, we appreciate it. Thank you. It's good to hear from you guys during the session, and having worked this throughout the interim, we appreciate feedback anytime we get it. So
Thank you, Mr. Chair. Again, I support the intent of this bill 100%, and again, appreciate very much the representative bringing this forward, and again, the work of Post. I think it's tremendous, and again, we want good policing, and we want officers trained well and reinvest in them and hold them accountable.
yeah, okay. Committee questions. Let's go to Senator Schuler and then back to Senator Cooper.
Thank you, Mr. Chairman. And the question I have, and I don't know if Mr. Walsh or the representative or you folks can answer this, but I did have a question, and I'm, again, working off the green copy, but on line 20, page 2, where it talks about none of this information shall be disclosed by the commission to any other person except as otherwise required by law. When would those kinds of things be required by law to be disseminated to the public or whomever?
Yeah, that probably would be best answered by a representative, but I believe under the Public Information Act, anything that would be contained within there. So there would certain aspects of a personnel file, when you get into medical records or perhaps psychological records, those would be ones that we would be very, very cautious with.
So the representative's still with us, and afterwards, we could sure bring you forward, Representative, on any questions that come up. Any follow-up, Senator Schuler? Senator Cooper?
Thank you, Mr. Chairman. Colonel, I certainly understand that there's a need for a lot of privacy on a lot of things that are in the personnel file, but you said something there a little bit ago about accountability, that you wanted to be able to hold them accountable yourselves. Obviously, that doesn't always work. So if not you, who should be holding them accountable?
Well, certainly if it's,
Colonel, go ahead.
Chairman, Senator Cooper, if not us, then certainly there should be a right to redress by the citizens, and that would be post in this regard, specific to certification or recertification under the statute.
Hold on.
Yeah, absolutely. Go ahead, Senator.
Thank you, Mr. Chairman. Well, Colonel, isn't that specifically what this is asking for?
Colonel?
Mr. Chair, Senator Cooper, yes, and again, my understanding of the bill as proffered is that it enables law enforcement agencies to provide corroborating evidence or information from a personnel file, or from, more specifically, a disciplinary investigation to corroborate the decertification side of the house. And that, I think, is what post is charged with. And certainly if an officer is decertified, they would not be able to continue in employment, not in Wyoming, as a peace officer.
Okay. Senator Cooper, any other follow-up? Anything else, committee? For the colonel or the lieutenant colonel? Lieutenant Colonel, any thoughts that you want to share, or you need to fill in for where the colonel forgot something?
Mr. Chairman, Committee, Josh Walter, Lieutenant Colonel for the Wyoming Highway Patrol. Nothing really to add to what the Colonel said. I just might give a little additional info. We have nothing to hide, and I'm probably going to reiterate a lot of what's already been said. We have nothing to hide. We do have the duty to protect personnel records. I think as written, as a representative here has already mentioned, and as Director Walsh has mentioned as well, at face value, I think this is good. I think it does a good thing. Our concern is what does it inadvertently do? And I think there's a lot of loose ends in here there's no definition of who can do the complaint, how often it can be done, how long after the issue can it be filed. So our concern is, although it should be focused on something direct to the investigation and direct to the complaint, if reading through this, it really opens the door to a lot of things that maybe aren't germane to the complaint itself. I mean, it's talking about initial certifications and, if you refer on that first page where it talks about the list under subsection B, being a U.S. citizen, being over the age of 21, those we don't have issues with. What we have issues with is this can open the door to the psychological, to good moral character. Those things are all listed in there that really this gives access to. So that's our concern. Not face value of it, but inadvertently giving access to deeper personnel records that we really have the duty to protect.
Okay, thank you for that. Questions, committee? Thank you both, gentlemen. Appreciate you being here. Yeah, thanks. Any other agency folks? Attorney General's office? Okay. Any other agency folks? Okay, I want to go to anyone else who would like to testify on House Bill 31 this morning. Anyone in the room want to come forward and testify? Please hurry on up. We've got 3 bills to go this morning, and the floor leader upstairs backed it up to 9:30. So unfortunately, that third bill is teetering a little bit. Go ahead. Good morning.
Good morning, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. We want to thank the committees, both during the interim and currently, for the conversations that we've had that get us to the point today. The discussion in the room this morning brings us to, I think, in the engrossed bill that you have, page 2, line 21, that except as otherwise required by law, does beg the question if post-commission might be required by law to release something that wasn't intended by this bill. And I would just like to give the scenario that when I was an administrator responsible for release of public records, I would oftentimes have in my possession other entities' or other entities' records. So we have a joint response to a criminal investigation, and the sheriff's office has their case report, and the police department and maybe the highway patrol has theirs. They provide it to the sheriff's office to send it all in one packet to the county attorney for continuity. If I was the sheriff and I was asked to release that report, I would not release the police department's report or the highway patrol's report because I was not the custodian of records for that. So I don't know how this works from post standpoint, but considering striking that line except as otherwise provided by law, those records still exist. There's a mechanism to get them from another entity, but I don't think that it should be, other people's records should be coming from post if they're released to the public.
So the question there, Mr. Thompson, is would that be required by law? I mean, I'm trying to get my arms around the situation you just described. You would not be required by law to release other entities' records that you happen to be in possession of. Isn't that correct?
I didn't believe, Mr. Chairman, at the time that I had the right to do that. I'm not an attorney and I don't work for the Attorney General's office to oversee this specific statute should it become, or this bill should it become statute. Just a question for consideration.
Okay, thank you. Questions of Mr. Thompson? Anything else on the bill? Mr. Thompson, thanks for being here.
Thank you,
Anything
Mr.
else?
Chairman.
Okay, thank you very much.
Thank you.
Appreciate it. Anyone else want to testify on House Bill 31 this morning? Do we have anyone online, Pierre, with a hand raised? Representative, you want to come back forward, please? Share any thoughts you have. It seems like the concern rests on page 2 primarily, and there were a couple of questions. Do you want to walk us through a couple of them, maybe? Any perspective you can give us?
Sure, Mr. Chairman, thank you. So one of the questions was required by law. I mean, I think if the court were to subpoena. So I want to give you an example of personal experience. The officer involved in this case I have filed police reports against for showing up at my house. Post did their own investigation and interviewed him. If we take out this required by law or this concern, one of my concerns would be if the courts were trying, there was also a settlement case in this case as well that costs the county $1 million. I don't know how this kind of mucks up that required by law. I will say, I think our Title 16 statutes are pretty solid. They've been working for years, and so has our post records access. They've been here since the 70s. They've been able to access records. It's just now that the court has said that your statute isn't clear. I don't anticipate anything necessarily really changing, except in cases where agencies are afraid of being sued by law enforcement because their records were shared. I don't think that, and some of the other issues are brought up about like the moral standard of law enforcement, and that, well, that's up to post's interpretation. It always has been. In comparison to the state bar, you're an attorney, you have to answer to the Wyoming State Bar if you engage in some sort of misconduct. They can pull your text messages, your bank records, anything that they need. And I would submit to you, committee, they don't have the legal right to kill you. So I don't think that we're asking too much to allow the certifying agency to ask for these records. If we were to strike, and maybe I'm misinterpreting the Colonel's amendment, but line 18, if we're striking suspension, revocation, or termination, are we now saying that post can't investigate cases where there's maybe been egregious misconduct? That is bad for law enforcement. What I watched in my community is my community no longer trusted law enforcement until there were major changes in who the sheriff was. People were afraid to be pulled over. If we want to protect the sanctity of the legitimacy of law enforcement, we have to allow for an accountability mechanism. If you strike those lines, I don't think that exists anymore.
Thank you, Representative. Appreciate it. Any questions of the representative? Any questions? Senator Cooper first, and then Senator Schuler.
Thank you, Mr. Chairman. Representative, I'm not sure that I'm seeing the loose ends that are supposedly flying around in this thing. Can you direct me to some of them that the Colonel referenced?
Go ahead, Representative.
Thank you, Mr. Chairman. You know, I certainly, maybe there's things that I've missed, but Senator Cooper, this bill has passed the House now twice. This bill's been worked several times. This is the first time it's coming to this committee, I think, for consideration in its current form. I don't see any loose ends. I see that there are concerns about potentially people's records being pulled up, or that Post maybe doing more than what its job is. I think if that happens, then let's cross that road when we get there. If we're concerned about what this does down the road, that's a decision this body can make. But there's no evidence from between 1970 and now, to my knowledge, that Post is a witch hunt agency. And all we're doing is continuing to allow them access after what the courts closed and said that they can't.
Okay. Thank you, Representative. Senator Schuler?
Thank you, Mr. Chairman, and honestly, I would agree with you on page 2, lines 18. I really felt like those things needed to stay in, because to me, that was kind of the meat of the bill, is that I felt like it was really important that agencies be able to do a deep dive into someone before they hire them, or if there's been some issues, maybe be able to go back and look at their record. So I really agree with you on that. And the only question I brought up on line 21 was just what was required by law. I didn't really have an understanding of that, but that makes total sense that there's certain things in the statutes that already require that. So I just appreciate your, furthering my understanding of some of those things. So, and appreciate your thoughts on what the House did, because, we like to hear that too, even though we don't always agree with them. Thank you.
Representative, if you could pause with us for just a moment. Director, you're still with us on screen. I want to give you any opportunity to weigh in on this conversation, primarily related to page 2 of the engrossed version of the bill. And do you have any thoughts you'd like to share with regard to Senator Cooper, Senator Schuler's thoughts and questions?
Thank you, Mr. Chairman. And I've been marking up, I don't have the green copy, but I've been tracking on the old one and putting it in here. Where we talk about otherwise required by law, I can give you examples. Psychological fitness is a requirement to maintain certification in the state. I have had cases where a person was found psychologically unfit, either at their initial application or later in their career. If it's a level where it needs to be an event where they need to be decertified, those records are presented in a hearing with OAH. And so I suspect that would be an area that we talk about, or that we would consider required by law. So I would have the information. I would have to present that to a judge. In the past, when I've done that, I've emphasized that this is a personnel record, and I don't want this record to be part of the public file of the hearing. So at the conclusion of a hearing, the only thing that's released from Post would be the final outcome document. So it would be the finding of facts from the OAH judge, and then the final commission order. And none of the supporting documents would be included in that. And they have not in the past. And so I think that would be an area that a department head, certainly the legal body of a city or a county, would say, we don't want this information released. But ultimately it is not, but there is a step where it would reasonably go from me before a judge, and that would be where it ended.
So, Director, thank you for that. One question regarding how a complaint would come. That was one of the concerns from from our law enforcement, you would still have discretion, would you not? Depending on, just because a complaint comes in doesn't mean that you take it all the way to OAH. Is that correct? I mean, you're still going to have discretion with this bill.
Absolutely, Mr. Chairman. The analysis I did over a 4-year data or study, only about 59%, 60% of complaints actually went into some kind of disciplinary action. So there is discretion on that. I don't take that discretion solely. I will take the information that I've received. I'll also run that through the Attorney General's office, so that we've got that second level there. But all complaints result in some type of disciplinary action.
Okay, very helpful, Director. Anything, committee? Thank you, Mr. Walsh. Appreciate that. Representative, any final thoughts? Bring us home on House Bill 31.
Thank you, Mr. Chairman. Yeah, I think an important point that Post brought up is, the decision ultimately comes to the commission. So that's a group of folks. It's not one person making those decisions. So Director Walsh would do an investigation. He'd bring it to that commission. The AG serves on that commission, along with other members of law enforcement. So it would be basically a group of peers in many ways that would oversee that. And I just want to kind of bring us back to the September meeting when the mother, Robbie Ramirez, came to our meeting to implore this body to do something. While I can understand concern, particularly of public employees that are concerned about maybe some issue with their job. I don't want to take anybody's jobs away. That's not the goal of this at all. But the reality is that we have a real issue that's already happened. And so I'd hate to have perfect or the future of something potentially get in the way of what's already been a grave misjustice in our county. And so I hope that I can get your favorable consideration on this bill. I know we worked on this in the interim. I think it's solid. But that's up to you now to decide, Senate.
Okay.
Thank you.
Representative. Appreciate you being here this morning. I'm going to close testimony on House Bill 31. What's your pleasure, committee?
Move the bill.
Okay, Senator Furphy moved the bill and discussion. Any further discussion on this bill? Senator Cooper.
Thank you, Mr. Chairman. First of all, I'd like to say that I have a family member that spent most of his career in law enforcement. I'm very supportive of law enforcement, and I understand a need for a certain amount of privacy in these records. However, I also understand that the vast majority of law enforcement agencies and law officers really want the transparency to really show folks that maybe that blue curtain they're all worried about doesn't exist as much as some people think that it does. I think this goes a long ways to promote that transparency. This protects the good apples and hopefully gives us a better way to bring forward the bad apples. Thank you.
Thank you, Senator. Anything else, committee? Are you ready are there any suggested, question on the bill? House Bill 31, would you take roll here, please?
Senator Case?
Aye.
Senator Cooper?
Aye.
Senator Furphy?
Aye.
Senator Schuler?
Aye.
Chairman Linden?
Aye.
5 ayes.
See you, doctor.
Thank you. Thank you, Representative. So, committee, anybody have a burning desire to present this up on the floor?
I don't mind doing it.
Senator Schuler?
If somebody else would like to, though. Senator Cooper.
You do a great job.
We're right behind you.
You're one of my favorites.
Yeah.
We're right behind you if a fight breaks out, okay?
A little ways behind you.
Yeah.
Senator, thanks for that. We will back you up. That was a lot of work went into that bill throughout the interim, and so I I believe House Bill 30 is next up. Is that right? I don't have my list in front of me here. I don't want to get out of order.
Yes, 30 is next.
House Bill 30, Controlled Substances Act, Possession Amendments. It comes to us as a clean bill. This was interim work by the Judiciary Committee. We've got folks here to help us with this. So, yeah, that is just awesome. Sometimes we need a reminder to go back 6 or 8 months. We've worked this throughout several months here, but anyway, welcome. Good morning.
Good morning, Mr. Chairman, Senators. Again, my name is Kelsey Singleton, and I'm with the Wyoming Attorney General's Office, and I represent the Division of Criminal Investigation, which includes the Crime Lab. As a quick refresher on House Bill 30, this bill came out of DCI's request during the interim to address an issue that the Crime Lab had encountered with prosecuting cases under 35-7-1031. 1031. 35-7-1031 includes criminal offenses for possession, manufacture, delivery, and possession with intent to deliver and manufacture controlled substances. It distinguishes violations based on the schedule of the controlled substance, the form of the controlled substance, the type of the substance, and the weight of the substance. Specifically with regard to the form of the controlled substance, the statute distinguishes violations based on whether the controlled substance was in plant form, liquid form, powder or crystalline form, capsule form, or cocaine-based crack form. There are various methods and forms of ingesting and using controlled substances, and we're seeing even more today with the use of THC-infused substances, such as edibles, as well as an issue that came up several times in different counties with black tar heroin not squarely fitting into one of these categories. So law enforcement has seen that increase, and certainly there doesn't seem to be any importance in the distinction of the controlled substance based on form. So what this bill does is it keeps the penalties for these offenses relatively similar to what they were prior to the amendments. We're just removing the consideration of forms for the prosecution. So there are consideration of the schedule of the controlled substance, whether it's Schedule 1 through 5, the specific controlled substance, whether it be methamphetamine, fentanyl, heroin, et cetera. There's also a consideration of the weight to determine whether it is a misdemeanor or a felony. Like I said, nothing really changes criminal prosecution-wise for what is considered a felony versus misdemeanor, other than there's a few kind of nuanced exceptions. Crack cocaine used to be 0.5 grams, and now it'll move that up to 3 grams. I did speak with the crime lab about whether or not they had a concern with that, and they just don't see a lot of crack cocaine anymore. So it wasn't very concerning to them. Additionally, THC products will all fall under that higher threshold of 3 ounces. Before it was just kind of hit and miss depending on what the THC was infused in, what the felony misdemeanor weight was, and now it's the same across the board. So I know you have a lot of work today, so I will answer any specific questions, but from the House perspective at Judiciary, I think this bill is ready to go.
Ms. Singleton, thank you. Always really helpful to have you alongside. This is tough for some of us because we don't work it every day. And walking us through it's really helpful. So I hope that maybe we can even steal some notes from you if the bill progresses from here. Any concerns come up on the other side, or any concerns since we met in the fall and passed this out of committee? Anything come up that you would recommend this morning, or do you feel like it's good to go?
Chairman Landon, I think it's good to go.
Okay, questions, committee? Ms. Singleton? Senator Schuler?
Thank you, Mr. Chairman. This is just more of a curiosity thing. What is it that law enforcement is seeing most of in terms of some of these products? Is it more of the infused THC stuff? Is it, you mentioned black tar heroin. I mean, what is it they're seeing most of the time when they're picking up folks that have these issues?
Ms. Singleton?
Mr. Chairman, Senator Schuler, I don't know that I can speak for all law enforcement. I do represent DCI and handle civil asset forfeitures, which are related to controlled substance violations. And we see a large amount of methamphetamine and fentanyl in those cases. That's probably our chief concern. I do think we see THC products, but not at the felony level that we're seeing that methamphetamine and fentanyl.
Anything else, committee? Thank you so much.
Thank
Appreciate
you.
it. Is there any other agency folks with us today that would like to come forward? Let's go to the chiefs of police, sheriffs. Mr. Thompson. You're kind of a semi-agency. I mean, you know. Good morning.
Thank you, Mr. Chairman. My name is Alan Thompson, Executive Director of WASCOP. And I just want to speak to the thoroughness of this bill and the vetted process that it went through in the interim. And from a law enforcement practical standpoint on the street, it does two things. It clarifies the substances by name rather than by form. And as we look over the last, 25 years at least, in my experience, the form of the drug changes daily, but the name of it and the contents of it don't. So this helps clear up that language. And secondarily, it helps new officers understand the application of the statute. And I do believe that this law will help law enforcement do a great job going forward. And I'd stand for any questions if you have any, sir.
Okay, any questions for the sheriffs and chiefs? Thanks, Mr. Thompson. Appreciate you. Anyone else in the room like to testify on House Bill 30? Anyone online? Okay, if you'd like to let them both in, and we'll start with one of the gentlemen. Be glad to take their testimony on House Bill 30. Okay. Welcome this morning. If you want to unmute and turn on your video, we can see you that way. You don't have to turn on the video if you don't want to, but good morning. Welcome. If you could introduce yourselves for us. Welcome to Senate Judiciary this morning.
Hello, Chairman. My name is Sam Watt with my wife, Alicia. And we would like to talk about HB 0030. Since the inception of our business, we have experienced significant growth, expanding to 5 Wyoming counties, and also employing 34 individuals with access paid healthcare benefits. Additionally to our business, we have contributed over $500,000 in tax revenue to the state of Wyoming. It is reasonable to estimate that the state has garnered millions of dollars from the hemp thrive industry. You have 2 bills that affects this. The Bill SF32, which we'll speak later on, seeks to reclassify hemp and hemp seed as a controlled substance, a move that directly contradicts federal law. The DEA has already removed hemp and its derivatives from the list of controlled substances, aligning the provisions of the 2018.
I'm sorry to interrupt, but just so you know that the other Bill 32 is across the hall this morning.
Yep.
The bill
Yes,
for our consideration is just House Bill 30.
Okay, so we'll just talk about House Bill 30 then.
Yep, thank you very much. Appreciate that.
So therefore, any attempt to reintroduce hemp into the controlled substance scheduled at the state level is both unnecessary and legally problematic. It is crucial to recognize that hemp is federally legal and can be transported across state lines without restriction. The 2018 Farm Bill supersedes any conflicting state law and ensures the free flow of hemp commerce throughout the United States. Under its provisions, no state or tribe has the authority to prohibit the interstate transportation of the hemp produced under either the 2014 or 2018 Farm Bills. In light of these legal considerations and the potential economic repercussions, I urge you to oppose HB 0030 and any similar legislation and undermines the hemp industry in Wyoming. Instead, I encourage you to support measures that promote the growth and sustainability of our state's agriculture sector. Thank you for your attention to this matter. I look forward to your support in safeguarding our business and the broader interest of Wyoming's hemp community.
Mr. Watts, thank you for that. I'm trying to track in, based on your testimony regarding hemp, I assume it's the THC content reference in the bill that concerns you. Is that how
Sure.
we're drawing hemp into the Controlled Substances Act?
Yes, sir.
Okay. Committee, any questions for Mr. Watt?
So,
Senator Case.
thank you, Mr. Chairman. So, Mr. Watt, is your testimony that, and I'm trying to understand this, since we, for example, in terms of talking about marijuana or tetrahydrocannabinol, it doesn't talk about the potency. It only talks about has an amount less than 3 ounces. It doesn't actually talk about how much THC is in there. It just talks about, so it could be a tiny, tiny amount of THC in the marijuana or whatever, but the measure is the volume of the material of 3 ounces. Is that your concern? Is that what we're getting at? No, please
sir.
straighten it out.
Yeah, Mr.
Because
Watt.
I don't understand how the hemp industry is affected by this. I don't. I'm sorry.
Yeah, thank you, Senator Case. Mr. Watt, go ahead.
Yes, Chairman and Senator Case. So there's a lot of confusion, and I see it, and it took a lot of talking to farms and stuff, and people in the industry that knows it and stuff like that. So what it's so confusing is that they're trying to take the product of the hemp product and add THC into it overall. It's confusing the language, and state of Wyoming follows the 2018 Farm Bill to the T, and it only really talks about the Delta 9 THC has to be below 0.3%. So that's where the confusion is. I understand DCI's problem on that. I totally get it. I would like to see regulations because there are a lot of bad actors in this industry all across the United States, not just in Wyoming. But regulation is key here. But as long as we follow the federal law, I think it's very important.
Thank you, Mr. Watt. Anything else, committee? Appreciate your testimony this morning, folks. Thank you. Let's move on to our next visitors this morning. Pierre? Okay. Are you able to get them here? Okay. Okay, I think we've been successful. Good morning.
Hi.
Welcome to Senate Judiciary this morning. We're working on House Bill 30. Would you like to testify?
Yes. Yes, I would. My name is Stephen Clark. I live in Campbell County, Wyoming. I just urge you guys to consider the legalization and regulation of the marijuana in Wyoming. This is a complex issue with various perspectives. I believe legalization presents a responsible path forward and prioritizes the public safety, economic growth, and individual liberties of our constituents. I do not think that we should be holding our constituents as criminals. Regulation, legalization allows for implementation of a regulatory framework that sets standards, safety, production, distribution, consumption, and it can help reduce the availability of unregulated, potential harmful marijuana products. Studies have shown that legalization can lead to a decrease in crime associated with the black market sale of marijuana. It has a tax revenue. Legalization and regulation create new opportunities for taxation, generating revenue that can be used to fund essential services and programs. Job creation. A legal marijuana industry can create new jobs in various sectors, including cultivation, processing, retail, and tourism. Individual liberties. Responsible adults. Adults should not have or should have the autonomy to make informed decisions about what substances they consume, as long as it does not infringe on the rights of others. Personal choice. Legalization respects the individual's right to choose and remove the criminal stigma associated with marijuana use for many responsible adults. I urge you to carefully consider the potential benefits of legalization and engage in this open dialogue with your constituents. Thank you for your time and your consideration.
Thank you, Mr. Clark. Any questions for Mr. Clark? Okay, thanks for being with us this morning. Appreciate it.
Thank you. You guys have a wonderful.
We sure will. Thank you. So, one more time, anyone in the room want to testify on this bill? Okay, I'm going to close public testimony. Committee, what's your pleasure on this bill? Moved by Senator Cooper. Discussion.
Mr. Chairman,
Senator Case.
I think I've been asleep at the switch, but is the purpose of this bill to get around the concentration things that we had problems before? And it's kind of connected to when there was a Cheyenne judge that said the volumetric measure of an edible product and whether that constituted the offending amount or not, or was less. Is that what we're doing here? And Ms. Chambers might be able to help us, because it comes down to each time it specifies an amount, but it says nothing about potency or concentration. So is that where this thing ends up? And
Senator Case, I remember what you're talking about. We've dealt with this, through the years. I don't think that is the initiator, but Ms. Chambers, we could use your help if you'd like to weigh in on this. I think primarily, I think Ms. Singleton and others told us throughout the interim, it's more of pulling some things in to these statutes that have not been there before. But Ms. Chambers, weigh in for us, if you would, please. Go ahead, Senator Cooper.
I'd just like to clarify that this is Ms. Chambers.
Yes, thank you.
Inside jokes there, I'll tell you about it.
Yeah, okay, good enough. So, no, please, good morning.
Chairman, good morning. Kara Chambers with the Wyoming Attorney General's Office. Yes, and I am, followed this through the interim and really using Kelsey's notes. The issue that came up in Laramie County was the form. Was that the statute describes marijuana as green leafy matter, and that when it was in a different form, they weren't able to, or the judge felt that they couldn't prosecute that. So what this bill was doing was, as Ms. Singleton explained, removing the form so that we could talk about the drugs and their potency and what levels, which remain the same in the statute as it always has been. We talk about carrier agents and all that whatnot. That's not really being affected by this bill. This is removing the forms, because what we have seen is that drugs come in different shapes and sizes, whether it's gummies or edibles or liquids or, what have you. And this was trying to get around this, saying like, look, if you have a drug in X concentration per the schedule, it doesn't matter what form it comes in. The other little note that I'd like to clarify is that the interplay between the Senate file that is across the hall right now and this bill is that it's clarifying what is legal hemp and what isn't hemp anymore, because it's had psychoactive substances added to it. And that was the bill that we had a couple of weeks ago that is across the hall today. And so just to touch on the earlier gentleman's testimony, that nothing in this bill nor the other bill does anything to harm legal hemp, but it does define what is legal hemp and what is no longer legal hemp because of additives. And so I hope that answered the question as far as it's not talking about the concentrations per se. The hemp bill talks about concentrations in the sense that if you add things and you get beyond that 0.3, it's no longer legal hemp. This bill is really just talking the forms of controlled substances as we already have them in our schedule and in the federal schedule.
So Senator Case, as usual, you were out ahead of me on that, and you were right. It did pertain to that. You want a follow-up question on that?
I'm trying here, Mr.
It was about form.
Yeah, so, well, here's my, if we go to the part on page 5, Romanet 10, we're talking about marijuana or tetrahydrocannabinol. And so I sort of know what marijuana is, green leafy stuff. There's good stuff and there's bad stuff, I understand, you know. It has different potencies, but it's measurable. You could measure 3 ounces of that marijuana. What is a tetrahydrocannabinol? That's not pure THC, I'm not sure what that means. So like if you made a mixture, maybe it's a food product. People cook things with marijuana and then they eat it. So now, how do you measure 3 ounces of that if it's in a 8-ounce tray of brownies, for example? So, I mean, to me, the thing hasn't gone away, and I realize they're not trying to solve this. They're trying to say, let's not worry about the form. But then all of a sudden, the form comes up.
The weight.
Yeah, good question, Senator.
No, it's not, but I'll do my best. Thank you.
We might be taking out the reflector poles here and getting off
gosh.
the highway, and we could spend some time, but it's a good question. So
Chairman Landon, Senator Case, that particular section is talking about the weight. So 3 ounces. And I believe, and this is where, I can maybe pull Sarah from the lab if she's done in the house to testify. But I believe they include the carrier agent. So if you had a brownie that was over 3 ounces, even though it may have had a very small concentration of marijuana or THC or tetrahydrocannabinol, which I believe is the same, you might have what would theoretically be a misdemeanor amount of marijuana, but because of all the carrier agents that it could be charged as a felony. And that is something that this committee has waded into for years. I'm going to quickly get beyond my depth to talk about that, but that particular 3 ounces is talking about the weight of the product.
yeah, go ahead. Senator Case, go ahead.
All right, I feel like hallelujah. Somebody understands what I'm saying.
I understand what you're
For the
saying.
first time ever, maybe. Before, where the law was vague about form, you couldn't have done that. You couldn't have done that. So, so this is a substantial change if you think about it. It does make prosecution potentially easier, and you can go to Colorado and you can buy a legal product, and you can bring enough in here that's a misdemeanor amount of legal product. It might be an edible product, and it might specify it's legal in Colorado. You bring that edible product into Wyoming and you are captured with it, it comes under the weight. You take that edible product and you throw it into something else and let it dissolve like a liquid, like a pop, or you bake it into a brownie, all of a sudden you go to the felony levels with the same amount of stuff that in a different form would have got you a misdemeanor charge. This is what's driven me crazy about all of this for all this time. Yeah. And this is like a backdoor way to get at that.
Well, so Ms. Chambers, do you want to weigh in on that? I would just say that this bill has been throughout the year discussed and worked, and we haven't specifically gotten into the kind of weight things that Senator Case was just outlining. And, you know, regardless of where this bill goes or how it goes, we probably still could put a lot more work in on this and dive back into this, this weight thing. But I remember it's been a really tough issue. Go ahead, Ms. Chambers.
Chairman Land and Senator Case, yeah, I mean, that, I don't think that was the intended runaround, but the forms question has always been an issue, and that was a lengthy discussion in the interim, probably in, gosh, it might have been 2017, 2018, where there were concerns that someone could have a 12-ounce soda that was laced with THC, legally purchased in Colorado, illegally brought to Wyoming, and that would absolutely come across as a felony amount because of the lab would have to consider the carrying agent. With that being said, I'm going to pass the baton to our DCI lab and try to paraphrase. The concerns are about weight versus concentration. And the question was specifically about, I believe you were on
So we're on page 5.
5,
Paragraph
that
10.
middle paragraph about 3 ounces of marijuana.
And what that language does, it appears as though it brings everything into play. I mean, when we talk about it can be any kind of substance. Well, how much of a plate full of brownies, for example? It doesn't take a very big brownie to be above 3 ounces. Does that make sense? Good morning. Please introduce yourself for the folks out across the land, okay?
Good morning, Chairman. I'm Sarah Barrett with Division of Criminal Investigation, State Crime Lab. And to answer your question, 3 ounces is roughly 85 grams. I'm not sure the weight of a brownie per se. I will say gummies generally run 1 to 3 grams in weight. And these are generalizations, of course, because we see lots of different evidence. And as the bill is written, it would mean anything that contains THC. And then, of course, we have to consider the hemp law. So it would be THC above 0.3% at 3 ounces would then be a felony weight.
So,
Senator Case, go ahead.
So, Mr. Chairman, I could go to Colorado, I could buy a single brownie, or a single, one of those gummy things, okay, of known concentration, and whatever that is. I could bring that into Wyoming. I could dissolve it in water and use it to mix my brownies with, and end up with a plate of maybe a pound of brownies with that one gummy in it. And I can prove in the court that it was only one gummy that I put in there. Now I would be charged under a felony law.
Ms. Barrett?
I could be. I'm not saying, I know that,
So
Chairman,
misdemeanor amount becomes a felony amount.
based
When
on
you
the
turn it
carry.
into something else, go ahead.
Chairman, Senator Case, I think we would have to also consider the 0.3% THC. And so and that's by weight. And so if you took one gummy, and I believe this is still true in Colorado, their serving size is 10 milligrams. By weight, if you take 10 milligrams of a gummy, I don't believe it'll be over 0.3 in a gummy form. But then if you were to take the 10 milligrams from that gummy and bake yourself a pan of brownies, that obviously is much heavier. And so your THC in the brownies would be much less than 0.3% THC. And so I think at that point, under the law, it would be considered hemp and not a Schedule I controlled substance.
Okay,
Mr.
go ahead,
Chairman.
Senator Case.
I obviously, you understand the math. We could jimmy the math to get above the point, the hemp threshold, and be still a misdemeanor amount of substance in one form, paying attention to the constraints of the hemp law, be above the hemp law, turn it into something else that becomes a felony amount based on the inert carrier stuff. That could happen. That could happen. It may not happen with the one brownie. I give you the hemp threshold, but mathematically it could happen.
Ms. Barrett?
Chairman Landon, Senator Case, I believe that could happen, and it does happen currently under our law without any of the changes that are in this bill. If you had, for instance, methamphetamine below a felony amount, which is 3 grams currently, and so let's say you have a gram of methamphetamine and somebody dumps it in a cup of water because they're in their car and the police are coming, they dump it in the water to hide it, to conceal it. Now you've turned a misdemeanor amount into a felony amount. So that is already currently in statute.
Okay. Ms. Barrett, thank you. Any further questions for Ms. Barrett? Appreciate our lab partner showing up. That's helpful. Not a complete fix, perhaps, committee with this bill, but any further discussion on it? Okay, let's go to a roll call on House Bill 30 here.
Senator Case?
No.
Senator Cooper?
Aye.
Senator Furphy? Aye. Senator Schuler? No. Chairman Landon?
Aye.
3 ayes, 2 noes.
I'd be happy to carry this one on the floor.
Oh, I'm sure that you'll be carrying it right along with whoever. Well, wish me luck upstairs, committee. You know, I'll take our interim work upstairs with House Bill 30. That will go to the Senate. Folks, we're going to unfortunately run out of time this morning on the cold case database and investigations bill. That's House Bill 29. We're going to have to carry that over till Friday morning. Is there any concern over being able to get here? I'm looking out at some folks. Is that primarily why you were here this morning, folks? Is that going to be a problem to come back on Friday? I'm so sorry we didn't get to it. We got a change upstairs that got in our way, and we're going to have to go gavel into the Senate. So we'll take up cold case on Friday morning, okay? Committee, anything else for the good of the cause? Next Wednesday morning, we have blocked out interim topics. 8 o'clock a week from today. To consider interim topics, so be sure and get those in. Any thoughts you have? Maybe we want to tackle a little bit of what Senator Case brought up this morning. Who knows?
I think so, yeah.
I think that's not a bad idea. But let's go to the Senate. We're adjourned.
In minerals last week, when I had to go over the hall, I've misidentified Ms. Chambers as